Hello and good evening, everyone. Welcome to LiveLaw Academy. I'm Rohit Rohila, your faculty and mentor for Judicial Services Examination. This is the second part relating to secondary evidence. We have already finished one part in which we discussed the rule of preference, why and how the primary evidence is preferred over secondary evidence. We saw the relevant provisions, the object behind rule of preference, best evidence rule. Then we saw different categories of secondary evidence, how the change has occurred under Bharatiya Sakshi Adhiniyam. The three new categories have been added. Earlier, we found that secondary evidence, the categories were the copies made through mechanical processes, the copies compared with such copies, the handmade copies through human intervention without any mechanical process, then the counterparts, the oral accounts, the certified copies, they are all secondary evidences. Then before moving on to the new three categories of secondary evidence, we first saw the old provisions from Indian Evidence Act to figure out whether the categorization under the said act, under the old act, was exhaustive or not. Then we found that there were three different provisions talking about some additional some additional types of secondary evidence. And exactly these three categories have now found their place under the Bharatiya Sakshi Adhiniyam section 58. Right? Now, today we will examine a provision which tells us in what circumstances secondary evidence will be admissible. I already told you in the first part that it is not in every case that secondary evidence becomes permissible. Certain specific circumstances have been laid down under the statute. Let's see the section 60 of Bharatiya Sakshi Adhiniyam, which talks about the same. Earlier, it used to be section 64 of Indian Evidence Act. No much change. In fact, when you compare the two provisions, they are exactly the same. Nothing has changed. So let's quickly go through this provision word by word. Right? Section 60, cases in which secondary evidences relating to documents may be given. Right? Now, when you see 60, you can divide the entire provision into two parts for the purposes of better understanding. Right? Let me divide it into two parts. One above this line, one below this line. The first part actually gives us the circumstances in which secondary evidence becomes admissible. The second part, the latter part of this provision, is actually telling us what mode of secondary evidence will be taken. Right? These are circumstances. Once these circumstances are shown to have existed, then only as per these modes of secondary evidences you can prove what you could have proved by way of primary evidence. Right? That is the relevance of dividing it into two parts. Now let's see the circumstances. It says secondary evidence may be given of the existence, condition, or contents of a document in the following cases, namely. Let's stop here. Existence, condition, or contents of document. So you see here the broad phraseology is used. It is not only about the contents of document, it is also about the existence and condition. Right? So when you prove something as a physical fact, then also section 60 is applicable. If you want to prove the contents of the documents, then also section 60 is applicable. So it has a much wider scope. Then first circumstance, when the original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved, or any person out of reach or not subject to the process of the court, or of any person legally bound to produce it. right? Let's analyze it. When the original is shown or appears to be, this word appears is of significance here. It tells us that it is not beyond doubt that it has to be shown that it is in possession or power of these three different categories of persons. If the court is prima facie satisfied, then also you can permit the secondary evidence. First, in what case? When it is in possession or power of whom? The person against whom the document is sought to be proved, the opposite party. The opposite party. For this clause, you can note down one decision of the Supreme Court. In this case, what happened? The the secondary evidence, the copy of rent notes were sought to be uh, rendered into evidence. The court did not allow it, saying that they do not seem to be of authenticity. They do not seem to be reliable. But when the matter reached to the Supreme Court said when this type of evidence qualifies to be secondary evidence under this subclause, and the question of reliability can be decided later on. Here at this stage, it was the question of admissibility, right? Please note down this decision. Nawab Singh versus Inderjeet Kaur, AIR 1999 Supreme Court 1668. 1668, right? Then subclause 2, of any person out of reach or not subject to the process of the court. Here, what must be understood is it is the person, not the document. The person is out of the reach of the process of the court. He is not subject to the process of the court. So it refers to the jurisdiction, right? It is not the document, but the person concerned in whose possession or power the document is, right? Then third subclause, of any person legally bound to produce it. Then the question is, who is legally bound to produce a document? You need to ask yourself whether the person concerned, the person in question, has any exceptional circumstance under which he can refuse to produce a document. If there is no such exception, if there is no such situation, and person is asked to produce, then he is legally bound to produce it. There are certain exceptions both under Indian Evidence Act and Bharatiya Sakshi Adhiniyam. For example, the title deeds in possession of a person who is not a party to the proceedings, right? Then you can avail those exceptions. But if no such exception is available, then you are legally bound to produce. So every person who is not falling under the exception will be legally bound to produce it, right? In such cases, if the original is shown to be in possession of such person, then secondary evidence becomes permissible. However, one additional thing has to be satisfied, and that is notice has to be sent under section 64 first, right? This requirement is very much important. And 60, when we see 64, we realize one more thing, that read the proviso, provided that no that's such notice shall not be required when the person in possession of the document is out of the reach or not subject to the process of the court. So even though the section says that notice has to be sent first, but that notice requirement is not applicable in these situations covered by clause A subclause 2. Please keep this thing in mind. Let's move on to the next. When the existence, condition, or contents of the original have been proved to be admitted in writing by the person against whom it is proved or by his representative in interest. Who is a representative in interest? Who represents the estate of, not only estate, the interest, general interest also of the other person. For example, the after the death of the father, the son, right? Uh, so if there is a written admission about the existence condition, which means physical fact of the document, physical existence of the document, or regarding the contents of the original, then secondary evidence can be given, provided that oral admission, the written admission is proved, and in such case, the second part of the section says what? That in such cases only written admission becomes admissible and no other modes of no other categories of secondary evidence allowed. Let's move on to the clause number C. When the original has been destroyed or lost, or when the party offering evidence of its contents cannot for any other reason not arising from his default or neglect produce it in reasonable time, right? Destroyed or lost. These two carry different connotations. The word destroyed here, the destruction, it means it indicates that the document is no longer in existence. It could be by someone else's fault. It could be due to some man-made or natural reason. Anything. The document is not in existence. But here you must remember that if the document was destroyed fraudulently, or it is suppressed by the party who is now seeking to give the evidence, secondary evidence for the same, then it will not be permissible, because then you will be permitting the person to take advantage of his own wrongdoings. That is never allowed, right? So that is the meaning of destroyed here. Then lost. Lost indicates not the permanent loss of the, that the document is no longer in existence. It indicates that it is not discoverable as of now. Right? The document is lost. It is not discoverable. It is not that it has completely been destroyed. Right? That is why these two terms are used here: destroyed or lost. Destroyed, permanent loss. Lost here means that it is not at this point of time discoverable. Right? So in this situation also you can give secondary piece of evidence. Right? Any mode that we have already discussed under section 58, because if you read second part, for clauses A, C and D, any secondary evidence is admissible, right? Then when the original is of such a nature as not to be easily movable, then also in that case secondary evidence can be admitted, right? And a document will not be easily movable for physical impossible reasons. Also, it covers those situations where moving the original document will result in some public inconvenience, right? Let's understand them by way of examples. So, what if something was written on a very huge stone, or there is some caricature on the wall, not physically possible to move that and ask the court to admit the same, right? It is physically impossible. So in that case, secondary evidence is allowed. Now, for something which is otherwise movable, but it will cause huge public inconvenience. For example, the ledger maintained with the bank, right? If the original is asked to be admitted in the court, there will be huge public inconvenience, right? For all the relevant documents, the ledger, the details, they will be with the court, which otherwise they are required in day-to-day activities, banking activities by the bank and also the customers, right? That becomes problematic. So it will cover those cases also. Then next clause says, when the original is a public document within the meaning of section 74, in that case, certified copy can be given. Section 76, we discussed it last time. Then in the first part. Then when the original is a document of which a certified copy is permitted by this adhenium or by any other law, then the secondary evidence can be given. But here, please read this, only the certified copy, nothing else. No other kind of secondary evidence is admissible. Right? So section 76 is one such example where Adhinium itself is saying certified copy is permitted. Then you have Banker Books Evidence Act, some provisions, I think it is section 4, right? Section 4 permits, let me just confirm. Yes, Banker Books Evidence Act 1891, section 4. It is the example of this latter part, or by any other law in force in India. If certified copy is permitted, you can give certified copy as a secondary piece of evidence of the original document. Then last, it is also very important. when the original consists of numerous accounts or other documents which cannot conveniently be examined in court, and the fact to be proved is the general result of the whole collection, right? It is again related to the inconvenience, the sheer inconvenience that this will cause when the relevant fact is the general result of the entire thing, right? For let's say the court is dealing with some case relating to forgery, fraud, or embezzlement that happened over a period of 20 years, right? So will you carry the documents to the court relating to a particular financial institution uh, which cover all the transactions of 20 years? It will cause inconvenience to the parties, to the advocates, and to the judges also, right? So in that case, what is allowed as a secondary piece of evidence, right? See this. Evidence may be given as to the general result of the documents by any person who has examined them and who is skilled in the examination of such document, right? No need to produce the entire thing. So for the purpose of our example, a chartered accountant can examine all those transactions and then give his opinion about the general result as to what can be made out of those details, those transactions, right? That will be a secondary piece of evidence allowed under this section, right? Now, last time I told you when we were discussing the categories of secondary evidence, section 58, I told you that why the word seen is used there and not the word reading, because it has something to do with the definition of the word document itself. Document has been defined very broadly. So document does not merely mean a piece of paper. It can be stone, picture, painting, caricature, anything, right? And that is why I told you that the word seen is used, and it was thought that seen is better than reading in this context. And for that, we have a very old authority, but you can always cite this. MAMI, these two are separate. MAMI, MAMI versus Kalandar, KALLANDER versus Kalandar 54 IA 61. IA means Indian Appeals, right? So this is a case which actually happened during the time of Privy Council, right? So in this case, it was observed that this was pointed out that seeing includes reading. Okay, this was it as far as the secondary evidences are concerned. Some provisions were touched in the first part, section 60, which required more attention. We have discussed it today. Then, for the purposes of electronic evidence, we have already discussed it in a separate video. You can also watch that, right? And in case you have any doubt from this session, then you can let me know in the chat box. Please let me know. Is there any doubt regarding any of the clauses and sub clauses that we discussed today? Anything? Meanwhile, I would like to make an announcement, a quick announcement that the registration for the next batch will be closing today. If you were in dilemma, uh, feel free to reach out. There is still a window left, and you can make the registration, and then we can study and learn the law together. It will be an interesting journey, trust me. Okay. Thank you. Thank you very much. Thank you. Okay, I think we can end this session now. Right, thank you. Thank you. New look, new start, JSF 2.0. Yes, absolutely. Absolutely. Change is the only constant, right? And in Hindi, we say that रुका हुआ पानी बदबू मारता है, which means if you will stop the flow, it is basically referring to the change. If you stop the flow, then things will decay, right? So we should always look for the changes, the better ones, right? Not the bad ones. Right? Any doubt regarding section 60 that we discussed? Change is the law of, yes, very correctly said. Change is the law of life. So Abhisesh, was this clear? Section 60? Any doubt from this? They always read this provision by dividing it into two parts, the way I suggested. Then it becomes very easy. First part tells us the circumstances. Second part is telling us the modes through which the original can be proved. The things contained in the original can be proved by way of secondary evidence. Right? What mode? Yes, sir. Clear. Thank you. Thank you. Okay. Then we'll meet again very soon in another session. Till then, take care. And in case you have any doubt, you can always, mention your doubts in the comment section. We will revisit. We always revisit the comments and we try to answer each and every question. Even if you were not there and you're watch in the live and you are now watching it, don't worry. You can always throw your questions in the comment. Right? Every single question will be welcomed. Thank you. Take care. Good evening.